And good afternoon. Welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This, of course, being your LawTube channel, where we look inside the real criminal justice system, not the one you may think we have, but the real one. And we do that in the context of cases that are in the news every day. Now, welcome to 2025, this being the first show of this new year. A lot of you remember joining me at the end of last year, back in December, when the Fulton County District Attorney, Fani Willis, got booted off of her prosecution against now President-elect Donald Trump. And I told you at that time that I was going to take a little hiatus, but I did not realize, of course, at the time that 2025, my goodness, we weren't going to have any legal stuff to talk about, at least in terms of court cases. We started off the new year, sadly, with the tragedy in New Orleans. And then, of course, it went right into the horrifying, terrible fires that are victimizing people as we speak now out in California. And, of course, we pray for those people there. This is the first opportunity that I've had. Many of you have reached out and said, "Hey, where are you, Phil? What are you doing?" Well, look, I mean, we just haven't had something to talk about until now, because what has happened? Well, as you'll see, Fani Willis has asked the Georgia Supreme Court to put her back on the case. All right. Now, by way of review, let's just take a look at what happened as the clock wound down, so to speak, on 2024.
Breaking news, the liberal district attorney Fani Willis, who went after Donald Trump in Georgia, just got kicked off the case. Georgia's Court of Appeals has just disqualified her from prosecuting the 2020 election case against Donald Trump and his co-defendants. They are citing conflict of interest. Well, no kidding. The court began looking into whether Willis should continue the case after that romantic relationship with the ex-prosecutor Nathan Wade came to light. The court said this: "While we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings." Yeah, well, she put in there he was making more than anybody else on the staff, and his resume didn't really match up what his job was going to be to go after Trump. There's that. The court did not outright, though, dismiss this case. It will now be up to the prosecuting attorney's Counsel of Georgia to find another prosecutor to take over the case and decide whether to pursue it. That process could be delayed if Fani Willis decides to appeal to the state Supreme Court and tries to get back on the case. President-elect Trump told Fox moments ago, quote, "Whole case has been a disgrace to justice, and that should not be allowed to go any further." Phil Holloway, former assistant district attorney, former Georgia police officer, and legal advisor to Georgia's Sheriff's Department. So you know that state, you know its legal system. Fani Willis, talk to me about what they saw outside of what we all knew.
Well, Harris, the statement or the part of the opinion that you referenced in the lead regarding there's no other remedy that will suffice is, I think, the very best and most important language in this opinion, because the appearance of impropriety, as the courts note, is oftentimes not enough. But this is the case because, look, this is the one that has the elected district attorney, taking lots of taxpayer money, funneling it to her admitted paramour, and then benefiting from that financial arrangement by virtue of all the romantic trips and the getaways and all of those things. So if it's not a direct kickback, it certainly has the smell of potentially a kickback. And her testimony, of course, they said had the odor of mendacity, which means that nobody believed her testimony when she tried to explain this. But it's more than the conflict of interest with Nathan Wade. This is also about what we call forensic misconduct. There's out-of-court statements where Ms. Willis goes into the well of a local church here in Fulton County, Georgia, which is full of potential voters and full of potential jurors, by the way, I might add. And she maligns and impugns the various defendants out in a very public way. Prosecutors are not allowed to do that. They're not allowed to try their case, so to speak, on the courthouse steps, nor in the well of a church. This is something that was actually predicted. I predicted this outcome. She can appeal it to the Georgia Supreme Court, but I've got news for her. the Georgia Supreme Court is not going to take this case. It's discretionary. They don't have to do it, and they won't. They are going to affirm the Court of Appeals, and this case is going to be effectively over because the Prosecuting Attorney's Council of Georgia is not going to be able to find another DA if they wanted to, Harris, that wants to take this monstrosity.
Is that the only issue with this case? Because, you know, that can change. People can come in and out of those jobs and so on and so forth. Is there anything else inherently true about this case that would get it dismissed at this point?
The former president, President-elect Trump, has asked the Court of Appeals to dismiss the case. And of course, in this opinion, they said, look, this is not, this doesn't rise to the level of dismissal. That's a separate issue. Now, there's other requests being made of the courts on the grounds of presidential immunity and that sort of thing. But this effectively kills the case, Harris. It's an orphan indictment. It's now going to be indictment without a prosecutor. And the Prosecuting Attorney's Council is not going to find any other DA that wants this. Look, they'd have to shut down their whole office, and they'd have to, just for this case, basically shut down all of their operations. They would have to redo everything that she did and try to fix the problems that she created. It's not going to happen.
All right, and that's where we left it there towards the end of December. She was booted off the case, and you heard my prediction there with Harris Faulkner on Fox News. I predicted that the Georgia Supreme Court would not take the case if asked. And of course, now they have been asked. And there's nobody better to help me break this down than Mike Davis, great attorney. He's with the Article 3 Project. He's former chief counsel for nominations with the Senate Judiciary Committee. And importantly, a law clerk for Justice Gorsuch at the United States Supreme Court. So big inside the law welcome to Mike Davis. Mike, thank you so much for joining me, buddy. There's nobody better, I think, than Mike Davis to help us understand what appeals are like, particularly in this case. Buddy, what top line thoughts? What do you think's going on here?
I think Fani Willis should cut bait and run here because I don't think she has a snowball's chance in hell of winning. Remember this. We know this, Phil. She hired her dumb, unqualified boyfriend, Nathan Wade. She paid him $250 an hour in Fulton County funds, $700,000. She took lavish trips with her secret boyfriend, Nathan Wade, around the world. Napa, Belize, the Caribbean. She's a Grey Goose girl, remember? Then she made up this testimony that, her Black Panther father told her to keep a bunch of cash laying around the house like a crack dealer or a prostitute, apparently, and she paid back Nathan Wade in cash. But what she failed to explain to the court and her defiant testimony, the just most shocking testimony I've ever seen, is how did she replenish that cash so she had several months of cash laying around to fulfill her Black Panther father's wishes, that she had several months of cash laying around after she spent thousands and thousands and thousands of dollars allegedly going Dutch with Nathan Wade around the world. She's obviously a crook. She's obviously conflicted. She's obviously lying. She perjured herself. She's just lucky that this Fulton County Judge, Scott McAfee, didn't find that she committed perjury. He gave her an easy out, and she's fought this, and she's going to keep fighting this, and she's going to lose.
Well, Judge McAfee, speaking of him, he did say that surrounding her testimony and that of Mr. Wade, there was this odor of mendacity. And for those of you who might have forgotten, let's just take a look at a small sample.
I'm asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
When the state was
Well,
able
it's
to
highly
follow
offensive
ups.
when someone lies on you, and it's highly offensive when they try to implicate that you slept with somebody the first day you met with them, and I take exception to it.
All right. Well, Ms. Willis, she'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did the meeting.
Okay.
He, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that conference.
Explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant. These answers are more than appropriate.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at the judges' conference?
He hasn't gotten to the point where Ms. Willis should be treated hostile in this situation.
I think we have.
I very much want to be here, so I'm not a hostile witness. I very much want to be
Not
here.
so much that you're hostile, Ms. Willis, it'd be an adverse witness. Your interests are opposed to Ms. Merchant's.
Thank you.
Merchant's interests are contrary to democracy, Your Honor, not to mine.
All right, let's
Judge, I
proceed.
would just ask that
We can keep things moving. Ms.
Thank
Merchant,
you.
next question,
Thank you.
please.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
So after that, you started dating shortly thereafter, correct?
A lie. That's one of you.
There's nothing more powerful than the odor of mendacity.
All right, Mike, that's it. Look, that's the recap there of some of the testimony at this hearing. And of course, you know, the judge Judge McAfee in his ruling, he found that there was an appearance of impropriety, if not an actual any actual misconduct or an actual conflict of interest. Now that you and I can probably take issue with that ruling, but that ruling sets up this petition for a writ of certiorari to the Supreme Court of Georgia now. So, look, what does this mean? What start off by telling us, for those of you who may not know in the audience, those of you who are watching live now, and by the way, there's 1,158 people in here now. Thank you so much. Please hit the like and subscribe button. And of course, for those watching on replay, Mike, can you explain what writ of certiorari means and what's going to happen next?
Yeah, the petition for writ of certiorari is a petition to the Supreme Court, usually the U.S. Supreme Court or the Supreme Court of a state, because the U.S. Supreme Court and almost every state Supreme Court has discretionary review in most cases, meaning they don't have to take the case. And it's an extraordinary writ where you're asking for the Supreme Court to take the case, in this instance, from the Georgia Court of Appeals. And let's just step back and explain what happened with this case. Judge McAfee said that there's an appearance of conflict of interest. And so therefore, the judge gave the option of either Nathan Wade getting kicked off the case or Fani Willis and her whole office getting kicked off the case. I think that's legally flawed, and so did the Court of Appeals. The Court of Appeals said, from what I understand from the ruling, is that the whole office gets kicked off the case because she's conflicted. She has a financial stake in this criminal prosecution because she's taken allegedly illegal kickbacks from Nathan Wade in the form of these lavish.
Well, yeah, it's important to talk about that because, you know, if she's, the theory is this, like, so she's giving these no bid contracts to her paramour, her boyfriend, paying him lots of money, well above and beyond what a typical prosecutor is going to make in that office. And by the way, he's not even a full-time prosecutor. He gets to maintain his own private law practice as well. And then this, of course, being a no bid contract where she didn't like open it up to the public to see who can get the most qualified person for the best use of taxpayer money. No, she just gave it to him because she has the power to do that. And then, of course, He then takes her on luxury vacations, and we just call it romantic getaways. And so the idea being is that she benefits financially from the money that she has steered to her boyfriend. Did I get that right?
That's exactly right. And that is not only an illegal conflict of interest, you cannot have a financial interest as a prosecutor in your criminal prosecution. We also have the very serious issue of federal honest services fraud and bribery and other very serious federal crimes, along with Georgia state crimes.
Well, what do you think, since you brought that up, what do you think, would there be any interest by any federal authorities to look into this? Because look, I mean, you're with Article 3, which is, among other things, against lawfare. And of course, we're getting ready to change into a new Department of Justice with new leadership. Would it be appropriate for an incoming Department of Justice led by Donald Trump at the top of the chain of command to investigate whether she has engaged in honest services or any other federal crimes?
Absolutely. And that's their job at the Justice Department, is to make sure we don't have corrupt prosecutors who violate the constitutional rights of Americans. So not only do you have the issue of honest services fraud and bribery and other corruption, you also have a very serious federal civil rights felony called 18 USC section 241, conspiracy against rights. When you politicize and weaponize law enforcement against your political enemies for non-crimes, that fits the very definition of 18 USC section 241. Remember, it is not a crime to object to a presidential election. It is allowed by the Electoral Count Act of 1887 and the First Amendment. If it were a crime, you would see Democrats in prison for objecting to Republican wins in 1968, 2000, 2004, and 2016. You don't see John Kerry and Al Gore and Hillary Clinton in the clink for objecting to Republican wins. This is a bogus theory down in Georgia that's brought by these two utter buffoon, corrupt, partisan prosecutors, Fani Willis and her dumb, unqualified boyfriend, Nathan Wade. So I would tell them they have been the hunters for several years, but on January 20th at noon, they may find themselves as the hunted legally, politically, and financially. So to Fani Willis and Nathan Wade, lawyer up, guys.
Well, it's certainly going to be interesting to see what happens and how that plays out. In the meantime, she's asking the Supreme Court of Georgia to put her back on this case. And so I think it's worth talking about what her legal theory is. I've put some of this is the state's, this is Willis's petition for a writ of certiorari, and she has to do a brief along with it, explaining why she thinks the Court of Appeals made a mistake. And they say that first and foremost, they didn't follow precedent. They didn't have any precedential authority, and they didn't explain their reasoning. Mike, you went to law school. I went to law school. A lot of people watching this video went to law school, and many people just know this anyway, whether they went to law school or not. Isn't it true that appeals courts, part of their job is to establish precedent? And when the existing precedent, that means the cases they've decided before, don't exactly fit, then they've got to, it's their job to square it, right? To see how this case fits into the prior case precedent. And courts of appeals, all appellate courts, they make precedent, do they not?
Yeah, I would say to Fani Willis, I don't think your precedent argument helps you like you think it does. I actually think it hurts you. It hurts you badly. The reason there is not a case on point that addresses the facts in Fani Willis's case is because Fani Willis's case is so egregious. It's so outrageous. It's so unbelievable. You wouldn't even find this in a law school exam, but because she's such a corrupt partisan buffoon, that they have to create new precedent for her case.
Well, and I posted some of this. See if I can. Let's see here. I want to share. I posted some of this on my the entire thing. I made a long thread and posted it all out on X. There it is. And I pointed out that. Well, let's see here. I pointed out in this thread that folks can see it for themselves. I've got the entirety of the opinion, or excuse me, the pleading screenshotted with a little bit of analysis attached to it. There's one of them, and I can't find it. I mean, I can't point my finger to it right now, but basically, she complains that there's never been a court that has done this before, and that prior appellate courts, here it is right here. She notes that case precedent says disqualification as an extraordinary remedy that should be granted sparingly. Well, the Court of Appeals actually agreed and said that this is the rare case where disqualification is necessary. And that's to your point, Mike, because it's so egregious. Is that fair? Do you agree with that?
Absolutely. I mean, it was used sparingly. That's why there isn't a bunch of precedent that the court can point to, because there aren't corrupt, partisan, buffoon prosecutors in the history of Georgia like we've seen with Fani Willis and her dumb, unqualified boyfriend, Nathan Wade.
All right. So let's go back to, the opinion, the brief here. Let me get back to it, because she also has made other claims here. She has said that here we go. She has said that the other thing that was wrong with this case, well, it's actually a sub argument to the first part, that they did not, the Court of Appeals did not sufficiently explain its reasoning. I thought that was very, very peculiar, arguing that they didn't explain themselves.
Yeah, I mean, I don't know what there is to explain. Fani Willis hired her boyfriend. She paid him $700,000 and she took lavish trips, kickbacks, right? I actually think the district court judge and the Court of Appeals went too easy on Fani Willis, because there's an actual conflict of interest here, not just the appearance of conflict of interest. And I think that the courts could have been a hell of a lot more harsh on Fani Willis. So I hope for Fani's sake that the Georgia Supreme Court does not take this case, which I don't think they will. I agree with you.
I don't either.
But if they do take this case, they may come down pretty hard on Fani Willis, a lot harder than the district court judge and the Court of Appeals did.
I'm here in Georgia, and I kind of study, our appeals courts, including the Georgia Supreme Court. And it's worth noting that the Georgia Supreme Court is the entity that polices lawyers basically throughout the state. And now this is not directly a misconduct case, as if it were like a bar complaint that bubbled up to the Georgia Supreme Court, but they take attorney conduct, including misconduct, very, very seriously. And so when they see this case with, just laid bare before them, and they see a prosecutor saying, Your Honors, on the Georgia Supreme Court, the trial judge did not find that I engaged in actual misconduct. He basically said it was an appearance of impropriety, even though there was this odor of mendacity surrounding my testimony. That's just not really a good look. And if they take the case and they have oral argument, I will sell tickets. I would buy a ticket actually to go and watch, because the questioning of whoever presents this case to them would absolutely be breathtaking. How in the world do you say to the Georgia Supreme Court that, the trial judge did not find an actual conflict of interest, therefore I get another chance?
Yeah, she should have just cut her losses. I mean, this is unbelievable that she's dragging this out. And she's dragging this out even after the American people heard all of these allegations and this so-called evidence from all these Democrat prosecutors and agents and witnesses and judges and other co-conspirators around the country when they ran this unprecedented Republican lawfare an election interference against President Trump. And the American people delivered our verdict in a very convincing verdict on November 5th. When President Trump won the popular vote, he won 312 electoral votes. He won the 7 swing states and he picked up the Senate, right? So the American people rendered our verdict on November 5th. And it's just amazing to me that all these other Democrat prosecutors are cutting bait and running, but Fani Willis is doubling down.
Well, she's making this other argument. And by the way, Mike's going to have to punch out before we finish the stream, and I'm going to stick around and we're going to talk more about her brief here. But her second argument, Mike, is that the majority opinion, of course, the Court of Appeals, there was 3 judges on the panel, so it was a 2-1 ruling against Willis. So the majority, that's the 2 of them, she says they disregarded decades of precedent in both this court, being the Supreme Court of Georgia, and the Court of Appeals, by holding that with the citation of no supporting authority, and apparently for the first time in our history, the mere existence of an appearance of impropriety is in and of itself sufficient to reverse the trial court's refusal to disqualify the DA and her entire office. And she pulled that word for word, quoting from the dissenting single judge who wrote the dissenting opinion. Essentially all she's doing, Mike, as I see it, really, is she's saying to the Georgia Supreme Court, pay no attention to the majority opinion because we like the minority opinion better, and we want you, Supreme Court, to adopt this. I think, Mike, if the Supreme Court takes this case, it's only going to be for the purpose of affirming the Court of Appeals. I really think they're going to say, no, we're going to exercise our discretion and not take it. But if they do take it, that I don't think can be seen as a sign that Willis is going to win. To your point from earlier, I think it might be a sign that they are going to take her down a notch.
Yeah, and I would say this. So I don't understand this argument very well from Fani Willis. She's saying that the Court of Appeals can't find any precedent, and then saying the Court of Appeals is disregarding decades of precedent. That seems to be in conflict.
Yeah, even though it's literally their job to establish precedent when it's necessary. That's what courts of appeals do.
Yeah.
Right. Well, so let's just say that this case does not get picked up, Mike, by the Georgia Supreme Court, or conversely, that they do pick it up and then they uphold or affirm the Court of Appeals, and Willis is off the case for good. Now we have an orphan indictment. That means an indictment without a prosecutor. Have you ever in your career seen something like that, particularly on something that's of such public interest and importance as this case?
No, and I would say to the Democrat operatives running this lawfare and election interference, the next time you do it, if you're not in prison after Pam Bondi opens a criminal probe on you for 18 U.S.C. Section 241, next time you better pick people who aren't utter buffoons to run your lawfare, like Fani Willis and Nathan White.
Well, look, you saw the testimony. You and I have been on other shows together. We met, I think, on Megyn Kelly's show, right? We've been talking about this for quite some time, and we've seen the testimony. We've seen the billing records. We've seen that there was billing by Wade that pertained to visits with the January 6th committee and with the White House counsel's office, and lots of collusion, in my opinion, with the entities in D.C. That, of course, were adverse to the interest of Donald Trump. So that, to me, is a legitimate thing that the American people need to know what happened. They need to get to the bottom of it. And I just don't know if the congressional oversight efforts are going to be enough, but we need to know exactly what type of interaction there was between Willis's office and authorities in Washington. Do you see any movement on that front?
At the Article 3 project, as a private citizen, I will be exercising my God-given right to speak and to redress government, and I will be very loud and very local, pushing for the Trump 47 Justice Department to open a criminal probe for conspiracy against rights under 18 USC Section 241. And I would investigate all of these cases against President Trump, whether it's Fani Willis and Nathan Wade in Georgia, Tish James up in New York, Alvin Bragg and Matthew Colangelo, Judge Mershon, Jack Smith, Jay Bratz, the January 6th prosecutors. This seems like a coordinated efforts by the Biden White House. You have Jonathan Sue, Biden's deputy White House counsel, waiving Trump's claim of executive privilege on behalf of Joe Biden, leading to the Mar-a-Lago raid and the two Jack Smith indictments. You had Nathan Wade, as you said, dumb enough to bill his time to meet with the Biden White House twice, 16 hours, $250 an hour, $4,000 before Fani brought her unprecedented indictment. And you had Matthew Colangelo deploy from the number 3 office in the Biden Justice Department to Alvin Bragg's office to resurrect that bogus case against Trump. This sounds like a criminal conspiracy to me, and we'll find out hopefully when Pam Bondi opens a criminal probe under 18 USC Section 241. Again, I would say to all these prosecutors and agents and witnesses and judges, even judges, for 3 years, you guys were the hunters. On January 20th at noon, you may become the hunted.
Well, we learned in the context of this and other cases that under the RICO statutes that exist both in the federal government and in the states, that defendants need not necessarily even know each other. So there doesn't have to be an express conspiracy. It can certainly be implied, and it can be people working together to achieve a certain goal, whether they even know each other or not. So there's potentially a lot that could perhaps be investigated by an incoming fresh set of eyes, so to speak, at the Department of Justice. I really appreciate your time. I know you've got a hard out here in just a couple of minutes. Mike, you want to tell everybody where they can find you and what you're going to be doing in the next several months?
Well, first, Phil, I think you would make a fantastic special counsel to come run this criminal probe for conspiracy against rights. I'm too crazy to get appointed or confirmed to anything, as everyone in the world knows over my loud mouth over the last several years. You can go to article3project.org, article number 3project.org. You can follow us on social media. You can donate. And the most important thing we're doing right now is taking action to confirm people like Pam Bondi as Attorney General and Todd Blanche as the Deputy Attorney General and John Sauer as the Solicitor General and Kash Patel as the FBI Director. President Trump is bringing in an all-star team. Justice is coming. And so I would say to these Democrats who ran this lawfare, lawyer up. Nobody's above the law.
Well, Mike, I appreciate all your time today. You certainly got the chat here riled up. Mama Rowe is wanting me to please take on that role. You know who I think would do great though at the Department of Justice would be Ashley Merchant. She's the Aaron Brockovich of this whole thing. And
she's a savage. She's great. She was Mike Roman's attorney. She was savage.
Yeah. Well, if it weren't for her, none of this would have ever come to light. This was, Donald Trump is the sort of the marquee defendant, right? He's at the, but it was the Michael Roman motion that everybody else joined. So if it weren't for her efforts, a lot of this would never have maybe come out. So
yeah, I agree.
All right, buddy.
Thank you very much, Bill.
All right, you bet. Thank you. And a big Inside the Law round of applause for our friend Mike Davis. See you, buddy.
Thank you.
All right. One thing about Mike, he always tells you exactly what he's thinking. He there's no gray area. You know exactly what's on that man's mind, and that's why I love speaking with him. I wanted to, however, spend a little bit more time going over the substance of this pleading here. By the way, I really appreciate there's 2,000 people in here now. Please do me a favor, hit that like button. That helps other people find this channel. This is the LawTube channel where we go, inside the real justice system to see how it really works in real life. And so when we have cases like this that are of public interest, we can use the things that happen and try to learn something. So we've been talking with Mike about this petition for a writ of certiorari, which is the discretionary application that Ms. Willis and her office has filed seeking to stay in the case. And the two big arguments that we were saying that she's made here is that, as best I can digest it, is that the Court of Appeals, they didn't follow precedent, and then she's complaining that they created precedent when there was no precedent, which I don't really understand, because that's what appeals courts do. And the other big thing that they want to do is they want the court to take up the dissenting opinion of appeals court Justice Land here in the Georgia Appeals Court. She says that they are disregarding binding precedent and flouting stare decisis. That's Latin, and it means things decided. In other words, the doctrine of stare decisis means that once something is decided, it's decided. But you know what? This has never been decided. So how can you flout the doctrine of what's been decided when it never has occurred before? I don't know, is this disingenuous? Does this pleading itself have the odor of mendacity? You be the judge. Tell me in the comments. Anyway, we get to her argument and citation of authority, and she just basically this summary that the prosecution underlying this results from an indictment alleging that the respondents and others participated in this conspiracy. Nothing earth-shattering there that we didn't already know. But she does say that, it says each step of this process has been conducted under intense media scrutiny. Well, do you think that she's responsible for some of that? Maybe by going into the well of a local church and giving speeches about it? Both the subject matter of the underlying prosecution and the resultant public interest make this case one of great concern, gravity, or importance to the public. What this is all going to, folks, is to the idea of whether the Georgia Supreme Court will take this case. They don't have to. It's discretionary. They could say no, and the issue is over, and the Court of Appeals ruling is the final ruling. She's trying to make the argument that because this is a case of great concern, gravity, or public importance, that the court should take the case. But she goes on to say, even if that weren't true, the Court of Appeals majority opinion would still imbue this case with the gravity necessary for the grant of certiorari. It says the opinion managed to overreach upward and downward, whatever that means, invading the provinces of the trial judge and also invading the province of the Georgia Supreme Court at the same time. And she goes back to this argument being that no Georgia court has ever identified or applied a standard for disqualification unique to prosecutors. Well, just because it hasn't ever been done before, even if that's true, and there is a standard for prosecutors, but even if this is true, why can't this be the case that is there's a first time for everything, folks, right? I don't think the authors of this brief fully comprehend that this is what appeals courts do. You have what's called cases of first impression. This issue of what she has done, all the things that Mike was talking about, all the things that she's done, we haven't seen before. We haven't seen in Georgia an elected DA indicting a former president for anything. And we haven't seen, and by the way, you didn't see state authorities thinking it was necessary to do this. We haven't seen a local DA in Georgia bringing in so many special counsels or special prosecutors or whatever she was calling these people. And we certainly haven't seen them doing that using no bid contracts. Normally when the head of any government agency or department wants to bring in an outside contractor, what are they supposed to do? They are supposed to They're supposed to usually advertise it. They're supposed to try to make sure they get the most bang for the buck, so to speak, no pun intended. And they have to be a good steward of taxpayer money. Okay. So I think that when one takes a step back and looks at this objectively, you'll have to see that this brief, I think, is disingenuous. I think it doesn't make a whole lot of sense on balance. Moving right along, however, she says that no Georgia court has ever reversed a trial court's order declining to disqualify a prosecutor based solely on the appearance of impropriety. Again, just because it's never happened before, so what? So what? We've never seen, just take a look at the news today. We see things in the news that we've never seen before. We see things in this courtroom and in this court case that we've never seen before. The majority opinion, that means the two judges on the Court of Appeals, says it does all of these three things. The opinion ignored precedent, created a new mechanical standard for disqualification uniquely applicable to prosecutors, usurping authority properly reserved to this court. That meaning the Georgia Supreme Court. What authority is she talking about? Usurping authority properly reserved to the Georgia Supreme Court. But she doesn't cite what that supposed authority is that uniquely belongs to the Georgia Supreme Court and only the Georgia Supreme Court. After all, this case went through the normal appeals process. The Court of Appeals has authority to hear the appeal. So she makes this statement that the Court of Appeals is somehow usurping authority. Well, look, that's how it works. You go from the trial court to the Court of Appeals. And if you don't like what the Court of Appeals says, you get to ask the Supreme Court to please, pretty please, with sugar on top, take the case and hear my appeal for one more step. So I don't know what this usurpation of authority is she's talking about, and she doesn't specify. And she uses language like it upended the abuse of discretion standard. So what she's talking about, the trial judge has a lot of discretion here. And normally when that's the standard is, did the judge abuse his or her discretion? That means the judge has wide latitude. Normally speaking, appellate courts don't disturb the abuse of discretion. They will defer in many instances to the trial judge. But for the reasons that I talked about in my last video on this, which is the one about the disqualification itself, go back and check it out. The Court of Appeals ruled that the judge's his remedy of disqualifying only Mr. Wade, that didn't cure the problem. Okay, so the Court of Appeals had no choice but to reverse him. Removing Wade from this prosecution team did not cure the appearance of impropriety. And so they had to do something different. They had to do what the defendants, Trump and Roman and Ashley Merchant and all the defense lawyers were asking. They had to boot Willis off the case. So just because there's an abuse of discretion standard, if that is in fact the standard, doesn't mean that it can't be reversed. So I don't know how she uses this language of upended the abuse of discretion standard. It doesn't make much sense to me. More just, I'm not going to read all this to you, but she talks about disqualification and abuse of discretion generally, which is kind of what I just went over. She gets into the rules of professional conduct, dealing with the rules of conduct. They eliminated reference to the appearance of impropriety, but look, the rules of professional conduct do not govern disqualification. The courts do. The rules of professional conduct are instructive or illustrative, maybe, but they don't govern things. Okay. The courts do. She says this court went on to note that the cases cited by the parties' briefs involved disqualification for actual conflicts of interest due to divided loyalties or the violation of client confidences. Because before now, guys, we haven't seen this. Once again, I keep coming back to the same thing. We haven't seen this kind of crap before. We have seen cases where private lawyers in civil cases may have some kind of a conflict of interest and they need to be disqualified. We've seen cases where prosecutors, maybe somebody gets arrested who works in their office and there's that kind of an actual conflict of interest. Those kind of things actually kind of happen all the time. This doesn't. This is very unique. Here in footnote 2, she again refers to the dissenting opinion in the Court of Appeals because she wants the Supreme Court to basically take the dissenting opinion, adopt it, and make that its ruling if they take the case. So, she just this whole thing. It's 61 pages long, but the essence of it is really just in the first 20 or so pages. She references the trial court's order. What I'm going to do here, let me go ahead and take this out, and I want to go ahead and bring let me share with you my Twitter feed because I can just basically do it that way a little bit easier, I think. And apologize for my voice, by the way. I've got a little head cold, but nothing serious. That's why my voice sounds just a little scratchy. All right, so here we go. That's the pretty long thread. As we pointed out, the Georgia Supreme Court does not have to take the appeal. She's asking to hear it on a discretionary basis. We've talked about the questions presented. As I point out, she says the Court of Appeals got it wrong by making new precedent. And as I've said just a few moments ago, that is, in fact, their job. And as I note here, I think, in my opinion, and Mike apparently agrees with me, that the Court of Appeals got it right. She says the state thus submits that the majority below, that is the majority of the Court of Appeals, erred in reversing the trial court's order declining to disqualify the DA. A constitutional officer based solely upon appearances as well as rejecting the trial court's remedy without identifying an abuse of discretion. Note, they are getting a lot of this argument from the single judge dissent in the Court of Appeals. I point out her argument in her brief. She says no Georgia court has ever identified or applied this standard unique to prosecutors. Again, while this may be true, it does not mean the appeals court was wrong. There is a first time for everything. She complains that the Court of Appeals created legal precedent. Again, I think that's just ridiculous, most ridiculous thing I've ever heard, perhaps. Complaining that an appeals court creates legal precedent when that's literally their job. It's literally their job. She does note that the case precedent says, quote, disqualification as an extraordinary remedy is an extraordinary remedy that should be granted sparingly. Well, that's what they did. The Court of Appeals agreed and said that this is, in fact, the rare case where disqualification is necessary. Again, she keeps on complaining about the Court of Appeals creating new case laws. It's just the same kind of complaint and stuff over and over again, restated in different ways, stretched out to 20 pages. It's the best way I can describe it. There is argument here that an appearance of impropriety alone does not suffice for disqualification. Well, this is the problem. Judge McAfee ruled that she had to get rid of Nathan Wade. And if she did that, that's all cool. We can move forward. But the problem is, even if there was no finding by Judge McAfee that there was an actual there was any actual misconduct or conflict of interest or impropriety. It was only the appearance of one. Removing Nathan Wade doesn't fix it. All of the things that have happened up to that point, including presenting the case to the grand jury and all that, nothing about removing simply Wade would restore the public's faith and trust in the validity of this process. Okay. So that's what the Court of Appeals is all about. Interestingly enough, she references case law, disapproving when, quote, case law disapproves when prosecutors are paid by a contingency fee had acquired a financial stake in the outcome of the case. Well, as Mike and I discussed, that's kind of what's going on here, right? She, the way the idea works is that she has a financial interest, at least in my opinion, in the mere existence of the case. And the longer the case goes on, the more complex and complicated it is, the more of a financial interest she has or had by virtue of her relationship. The more romantic getaways she could have and things of the sort. She's complaining that the trial court did not make a finding of an actual conflict of interest, rather that it found an appearance of impropriety. And let's not forget this odor of mendacity. Oh my goodness. This, thank you, Mama Ro. I want to point out a couple of these super chats here. Those get starred. It's hard for me to watch the live chat and to snag and notice things that are said. These get flagged. Thank you very much, Mama Ro, for the super chat. Thank you for the comment. Thank you, Lou Williams, for becoming a new member of the channel. These are the kind of things that help me bring this conduct to you. So thank you very, very much for that. All right, moving right along. The argument still being that the trial judge, Judge McAfee, did not find an actual conflict of interest. See how she's just repeating herself? She's just making the same argument, it seems, over and over, more of the same. You guys can read this for yourself, and maybe you can make more out of it than I was able to. The Court of Appeals said this in their ruling. They said, while we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated, and that no other remedy will suffice to restore public confidence in the integrity of these proceedings. So really, this is the crux of the whole thing, right? Was there something less than her disqualification that would have remedied this? And I keep coming back. The only possible answer is no. Simply getting rid of one prosecutor on the team doesn't undo any of it. I point out that Willis argues weakly, in my opinion, that the Court of Appeals was mistaken or they were wrong because they didn't provide much analysis to explain their central holding. Well, I don't know what else there really is to say about it, because they did say, they said, quote, this is the rare case, and that no other remedy will suffice to restore public. What else is there to say? What other analysis does she want to explain their ruling? Because that's it. That's the crux of it. She's adopting the dissenting opinion from the Court of Appeals and is urging the Supreme Court to do the same. She says the, quote, district attorney's relationship with SADA, Special Assistant DA Wade, had not actually affected the case in any way. Does anybody believe that? Do you believe that Wade's relationship with the DA did not actually affect this case in any way? Really? More argument from that the dissent should be adopted by the Supreme Court. She says the majority opinion creates an unworkable standard without explaining the basis for its conclusion that this is the rare case. How is it an unworkable standard to say basically you can't give no bid contracts to your paramour and then have the public find out about it, be embarrassed, and that not be something that the public loses confidence in the judicial process. How is that unworkable to say, thou shalt not do what thou did, Madam District Attorney? I don't know how this is supposedly unworkable. She's more complaining that the Court of Appeals created case law precedent. She says, at the very least, if an appearance of impropriety, absent an actual conflict, is enough, if that's sufficient to require disqualification of a DA, this court should be the authority. In other words, the Supreme Court should be the authority to clarify how and why. Okay, well, let's say for the purposes of our discussion here this afternoon that it should be the Georgia Supreme Court. Maybe they're just going to take this case and they're going to say, you know what, Ms. Willis, you're right. So we're going to take the case and we're going to say to you what the Court of Appeals said. You're done. You're out. That would be the only reason they would take the case. And by the way, I don't buy it. I don't think that the Georgia Supreme Court is the only court that, quote, should have the authority to clarify how and why DAs should be booted off a case. She says the Court of Appeals should not be able to establish such a principle. Okay, well, she's complaining that they don't explain why. Then she does, but she doesn't explain why. Why does she make this argument? Why does she say that the Court of Appeals should not be able to establish such a principle? Why not? I want to know why not? Why can't they? It's literally their job to review the orders of trial courts. She wants the dissenting opinion, as I said, to be made the order of the Supreme Court. The dissent in the Court of Appeals tracks the consistent refrain that without an actual conflict of interest or actual impropriety, the trial court's denial of a motion to disqualify a lawyer cannot be an abuse of discretion. And then the majority opinion, quote, cannot be reconciled with any of the cases cited. Well, they've already told you. The Court of Appeals says this is the rare case where we're going to take it out of that continuum and we're going to say that on the unique facts presented in this case, disqualification is the only possible remedy to clear up the appearance of impropriety. And she actually goes on to cite a lecture given at Emory Law School in 1982, which most certainly is not binding legal precedent. She says, as the Honorable Henry Friendly summarized in a lecture at Emory Law School, quote, when we are discussing the allocation of power between trial and appellate courts, I find it more useful to say the trial judge has discretion in those cases where his ruling will not be reversed simply because an appellate court disagrees. So she's doubling down on this idea that you can't really reverse a judge when the legal standard is abuse of discretion. We can find countless cases throughout the history, the judicial history, the legal history of the United States, where cases have been and will always continue to be reversed, even on an abuse of discretion standard, regardless of what the Honorable Henry Friendly in his lecture to Emory said in 1982. All right. So, folks, you can go to my Twitter feed and check that out. Read it for yourself if you are so inclined. Mike's guess, you heard it, was that the Supreme Court's not going to take the case, and I still think they won't. However, I will hedge my bet, and I will say to you that if they grant certiorari, they agree to hear and take the case, that they would be doing so only to affirm the Court of Appeals and to say, you know what, Ms. Willis, they were right. You're out. You're off the case. I may eat my hat. I'm terrible sometimes at making predictions, particularly when it comes to legal cases. But on this case, my track record's pretty good. So I'm going to stick with my initial instinct, which I said to Harris Faulkner last month on Fox News, which I said to you guys here inside the law last month. And what I've said today is my prediction is that she's off the case. It's an orphan indictment. So what does that mean? What does it mean to be an orphan indictment? It means that you're an indictment with no prosecutor. Fulton County would still have the case. It would still be assigned to Judge McAfee. There just would be no prosecutor. Well, Georgia has a solution for that. It's called the Prosecuting Attorneys Council of Georgia. It's a state agency. It's a small one, but it's their job, among other things. They support prosecutor offices. By the way, it's the Prosecuting Attorneys Council of Georgia that loaned one of their prosecuting attorneys to Athens Clarke County recently in the Lake and Riley trial. And they did a great job, and they handled that case essentially for the then now former DA of Athens Clarke County. So they assist prosecutors, but sometimes when prosecutors get taken off a case, either voluntarily or involuntarily, the law says that the Prosecuting Attorneys Council has to make a determination, do we need to appoint somebody else? And if so, who will that be? Well, assuming that they wanted to appoint somebody else, and I don't think that they would, but assuming they wanted to appoint somebody else, what prosecutor in his or her right mind, what DA in Georgia would want this mess? Because they would have to go back and they would have to clean it up from the very beginning. They would have to undo all of the things that were tainted by virtue of this appearance of impropriety. And that probably would mean starting back all over with a brand new grand jury, even perhaps an investigative grand jury. I mean, all the way back to the beginning. No prosecutor, they don't have that kind of money. They don't have that time. They don't have that kind of inclination to get into all this and do this all over again. So my prediction is the Supreme Court won't take it. And if they do, it's only to, again, tell Willis that she loses and she's off the case. But even if I'm wrong about any of that, if I'm right about that, my prediction is that the Prosecuting Attorneys Council is going to kill the case. And if they don't kill it, if they want to refer it to somebody, and I don't think they will, nobody's going to take it. So I still think we are at the end of the lawfare as it pertains to the state of Georgia versus these defendants. I think this case is over. All right. That's about all my voice can take for one day. Look, I'm going to keep coming back here inside the law. We're going to keep talking about cases that are in the news. We're going to keep talking about things that we can learn something from. Right now, we're kind of slow in that regard. It's all politics, as it should be. When you have a presidential transition, that's going to be in the news. We just don't have a lot of legal cases in the news right this minute. But look, we know that's going to change. We've got other things on the horizon. So if I'm not here as often as I was perhaps throughout the last year, it's simply because I'm not going to just come here and talk just to hear myself talk. I want to be able to talk about something meaningful. But you can rest assured I will be back here when we find out what the Georgia Supreme Court is going to do with this. And I will be back here when we have legal cases to talk about. I've got some things in mind. I've got some ideas of what's on the horizon that we'll be getting into. Okay. So 2024 was a great year. For Inside the Law, we had the YSL trial. We had all of this stuff going on, but there will be something new, a new crop of criminal legal cases popping up here in 2025 that we'll be able to do a deep dive into and hopefully learn something along the way. So until then, I want to say thank you to all of you. I really appreciate you being here. And please don't forget to like this video, tell your friends, tell your family. If you think this is kind of content that you can find some value in, spread the word. Subscribe. It won't cost you anything, and bring a friend or two. All right. I'll catch you back here next time inside the law.